All rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is a time set for oral argument in consolidated cases Thomas Kopp versus Physician Group of Arizona et al. Our case number CACV 16-0227, 0228, and 0232. Each side is allocated 20 minutes for your oral argument. Appellant may wish to reserve a portion of that time for rebuttal, sir. If you wish to do so, you need to keep track of your own time at the clock on the podium. Out of respect for counsel, I would ask those in attendance to make sure those cell phones are off so our discussion is not interrupted. We've read the briefs. We've conferenced the case. We're familiar with the record. We'd encourage you to keep that in mind during as you present your oral argument today. Our proceedings are being recorded digitally and visually and sound recording and posted to the website as well as then to YouTube in due course. So when you approach the podium, we would ask that you tell us your name and the parties that you represent. With that, Mr. Wright, you may proceed.
Thank you. Good morning. May it please the Court, I'm Michael Wright from the Udall-Shumway Law Firm in Mesa. I represent the appellants in this matter. 3 consolidated cases. We have referred in our briefs to IASIS as the owner of the corporate defendants in the case, so I'll refer to IASIS as the appellees if you don't mind. IASIS owns Phoenix St. Luke's Hospital and Tempe St. Luke's Hospital here in Phoenix. For a number of years, the Phoenix St. Luke's Hospital has had a bariatric program, a surgical program that has been successful. Excuse me. And there came a time when IASIS decided to install a bariatric surgical practice at Tempe St. Luke's, which is a smaller facility, a community hospital in Tempe. It marketed its program. It marketed that it had excellent surgeons and a full service support program of nutrition, nursing, etc. In this case, we sued Dr. Schlesinger, the surgeon who performed the surgeries, and IASIS. We alleged in the complaint and provided affidavits by Dr. Kunine and Dr. Hyde, which you have read, which alleged independent negligence on the part of Tempe St. Luke's Hospital in his bariatric program, in supervision of the program, in regard to policies and procedures that either did not exist or were inadequate, according to Dr. Hyde. We alleged that they had inadequate controls. We also alleged that in hiring Dr. Schlesinger, they were negligent and not checking into his background as well as in the nature of his procedures. Dr. Schlesinger, on these several patients, performed what is called a diversion with biliopathy or biliopancreatic diversion and a duodenal switch procedure. That's a kind of a complicated term for the kind of procedure he did, which was a radical procedure that robbed the patients of the ability to absorb adequate nutrition, setting them up for problems with healing of the wounds, problems with recovering generally from the procedure, and basically problems with inadequate nutrition. This procedure, excuse me, according to Dr. Kunine, was the wrong procedure to be performed on these patients. And IASIS, or Tempe St. Luke's Hospital, was aware of problems and complications developing from the kind of procedure that Dr. Schlesinger was doing on patients. It was our allegation that the IASIS was therefore independently negligent in several respects. There came a time when an early mediation was scheduled in the case before discovery, in which a settlement was reached within Dr. Schlesinger's policy limits, which were inadequate to compensate the full extent of damages for the several patients because of his aggregate coverage. As a result, Dr. Schlesinger insisted, as you would expect, on a release, a full release, in order to provide this settlement. He settled with the motivation to protect himself from an excess judgment, and it provided some compensation, but not full compensation for the damages sustained. One of our allegations in the brief is that if a hospital that employs a physician and supposed to supervise the physician is able to not participate in settlement and thereby hold the physician hostage to his risk of an excess judgment, that the ability of the hospital to not participate in the settlement and preclude the plaintiffs from proceeding against the hospital thereafter would have a chilling effect on settlements.
Mr. Wright,
Yes, sir.
I'm just assuming from this discussion that although Dr. Schlesinger's offer was conditioned upon the execution of a full release, it was up to the plaintiffs to decide ultimately whether to settle the case on those terms.
Yes. And the plaintiffs did make that decision and had to agree that any vicarious liability aspect of the claim against IASIS would be foreclosed and dropped, so that any derivative claim such as the vicarious liability was not a part of the suit thereafter.
But just to state the obvious then, the plaintiffs could have chosen to say we're not going to settle on that basis. We're going to continue in this litigation until the jury has resolved this case in its entirety or the case has been settled in its entirety.
Yes, Judge Winthrop, the risks of going forward in litigation in a malpractice case in Maricopa County are there, and so they weighed those risks, but put into the settlement agreement that they were preserving their claim against IASIS for its independent acts of negligence, not for its vicarious liability for Dr. Schlesinger. And so weighing those risks, it was the prudent thing for them to do. And the expectation was that we would then proceed to trial against IASIS for its independent negligence claim.
And don't those independent negligence claims still exist, Mr. Wright? And your clients can move forward in Superior Court on those claims?
No, because Judge Talamonte dismissed the entire case, holding that any such claims were derivative and therefore precluded from being able to proceed.
Well, the way I read Judge Talamonte's minute entry, and I have it in front of me, it says the court agrees that any independent negligence claims alleged against the defendants survive the settlement with Dr. Schlesinger, but also feel that the court cannot, with the exception of the nursing claim alleged in the Jensen case, identify what those claims may be. He doesn't dismiss the negligence claims. He says they still survive. He, in his own personal opinion, just can't identify what those claims might be.
That was part of the error in his ruling. He dismissed the claims because he did not understand the nature of the allegations of independent negligence against IASIS. One of the cases, the Jensen case, did have an independent claim that was discrete in that the nursing staff failed to protect him from a pressure ulcer from which he eventually died.
Okay, then I guess I'm confused because of the language I just read said that any independent negligence claims against the defendant survive the settlement. What was dismissed? If there's claims that independent negligence claims that survive, how does that follow then that they were dismissed by Judge Talamonte?
It should not follow. It was an error on his part. He treated it as though it were a motion for summary judgment and did not find evidence supporting independent negligence claims. But the case had not yet gone to discovery, and the case was dismissed without him evaluating or assessing the evidence supporting such claims. So he basically did not understand the nature of the claim.
Well, Mr. Wright, I'm trying to understand the timing of this because the minute entry that Judge Bean's referring to occurred at one point in time then it appears that the parties continued to litigate. And then the parties came to Judge Talamonte sometime later with a stipulated proposed form of a Rule 56B judgment, so that order could be appealed. That certainly implies that there were indeed claims that remained, that were being litigated, and in fact still remain in the case today.
Well, the parties understood and agreed that the dismissal by Judge Talamonte was based on his minute entry of finding of no independent claims against the hospital, which was the error.
But that's not what the judgment says. It says order dismissing the negligent credentialing claims, dismissing the negligent supervision claims, and dismissing the negligent hiring claims, and any other negligence claims that are based on or derivative of the negligence of Dr. Schlesinger. So it doesn't say that the entire case is dismissed.
Well, we would be pleased if it is still alive, but it is not, because based upon his dismissal of the negligent credentialing and the other claims that you just cited, the heart of the case against IASIS was dismissed out. The reason it took some time before the Rule 56B language was submitted to the judge was that there was an interim special action which was dismissed because of a lack of Rule 50B6 language or 50B4 language.
I understand that. It seems to be, based on your earlier presentation, you were talking about the nature of the independent claims against the hospital. It did sound, in fact, like there are claims, whether they are the heart of the case or not. Obviously, that's subjective. But you know how the program was structured, whether there were sufficient controls built into the structure of that program, and any nursing issues concerning post-operative care, those all survive. So are those the nature of your independent claims?
Those are part of them. Also, the credentialing claim was a substantial part of the case because of the nature of the procedures that Dr. Schlesinger was doing. Failure to supervise him, credential him, failure to dismiss him as the primary surgeon in the bariatric program. And I think that the appellees will admit that the understanding was, after getting that ruling and discussing the matter and so forth, that his ruling in effect dismissed IASIS, or the independent negligence claims against IASIS, in their totality. Now, the wording in the minute entry may not be as clear as that, but that was the understanding and the reason for the parties to submit it to a final judgment so that it could be appealed on that issue. His failure to recognize under UCATA the independent claims surviving the dismissal and the release of Dr. Schlesinger.
Counsel, let me see if I can play this back, because we do have a 54B partial judgment. So by definition, there's something still with the Superior Court. We don't have a 54C final judgment as to all claims in all parties. So that's how the case comes to us. Whatever is not subject to the 54B, we don't have appellate jurisdiction over. That remains with the Superior Court. And I think just by looking at the briefs, we are all struggling some to determine exactly what that something is. Not because we need to address it, but because we can't address it, because we lack appellate jurisdiction over that. But do I hear just the replay part of it with that
Sure.
long soliloquy that your challenge today is the dismissal of the negligence credentialing, hiring, and supervision claims? That's sort of it.
Yes, sir. That is really what is subject to appeal and what was the ruling which we are appealing. His ruling dismissing those claims. The other allegations against IASIS for its independent acts were really kind of peripheral to the primary claims of them allowing Dr. Schlesinger to perform the surgery that he did and not having controls over that. The other claims, such as lack of nutritional support programs and so forth, were really peripheral to that.
Well, and
So
as
that's what
Judge-
we're appealing.
Judge Bean mentioned, that was what the trial court struggled with, kind of determining what those other things are, what the things that remain pending. And the one thing he could point to was, with the exception of the nursing claim. And that's kind of what you're saying as well. Is that fair?
No, our claim is one of negligent hospital administration. There are nursing aspects to it, but the primary claim in the case against IASIS, and that which is on appeal, is the failure to have adequate hospital administration, policies and procedures and controls.
And I understand that that's when we add the qualifier, that's where we may have a gap in understanding. I understand that's what you perceive as the primary claim and what you now have confirmed you believe is subject to our appellate jurisdiction here today. But my point is that's not all the claims. There is that nursing claim, or at least the trial court thought there was, and we're here on a 54B entry of partial final judgment, not 54C final judgment. So at least somewhere, sometime, that court, who's far more familiar with these cases than I am, thought there was something that remained.
Well, actually, there are no nursing claims per se in terms of nursing care that was being provided or not provided. The claim is not having these services available, in addition to the negligent credentialing aspect of the case, not having what they marketed that they would have and what Dr. Hyde and Dr. Cunneen said they should have. Excuse me, I've been fighting bronchitis for the past week.
It seems to me, Mr. Wright, I mean, I understand that you have claims that you wish to litigate concerning hospital administrative liability, hospital administration as you characterize it. The question is, what remains of those after you apply Torres and the other cases, and which led the trial court to dismiss the negligent hiring, negligent supervision, et cetera?
Had the case gone to trial with Dr. Schlesinger involved and IASIS involved, excuse me, and the jury would be called upon to apportion fault under UCATA, there would have been additional specific items of evidence against IASIS that we were entitled to discover and present at trial. The status of the case at the time of the dismissal was based purely on the fact of the settlement with Dr. Schlesinger as wiping out the claim against IASIS. That's what we're appealing, and that's what we assert was error. We did not have an opportunity to flesh out, so to speak, all of the things that IASIS did wrong. We had enough with Dr. Cunneen and Dr. Hyde's affidavits to survive a summary judgment, but the case was not presented as a motion for summary judgment. It was presented as a motion to dismiss because of the release of Dr. Schlesinger purely. That's what we appeal. So whatever remaining claims may exist if it were to go back to trial, we of course would develop and present, and the jury would evaluate. But without the negligent credentialing and other matters that were specifically precluded by the ruling, we would be greatly impaired in our ability to prove up the case against IASIS.
I know below you pointed out to the court that what in fact was being presented to it was a motion for summary judgment. Did you submit a 56F affidavit saying we need to conduct discovery in order to develop a record so we can respond to this?
Well, it was not a motion for summary judgment. It was a motion to dismiss specifically because of the release as having deprived the plaintiffs of a claim independent against IASIS.
I know, but I thought you sort of objected below and pointed out to the court that you felt this should be a motion for summary judgment.
Well, no, it did not come up in that way. It was purely on the issue of whether the release of Dr. Schlesinger precludes the claim to proceed against IASIS. I just have a minute and a half left. I'll preserve if you
Very well.
don't mind.
Thank you. Mr. Meyer.
Thank you, Your Honor. May it please the Court, my name is Kevin Meyer from the firm of Browning, Oberg, Woods & Wilson on behalf of the ISIS defendants. The trial court correctly dismissed or granted Rule 54B judgment in this case on the claims that were derivative based on the settlement that plaintiffs entered with Dr. Schlesinger. And on that basis, we think that this Court should affirm the Rule 54B judgments and allow this to go back for whatever claims actually might possibly remain. We believe the trial court got this right and correctly recognized that independent claims, especially the nursing claim in the Justin case, should be allowed to go forward. And we absolutely agree with that was the correct decision. But we also agree that the court recognized that Law and Torres, the law case, Law versus Verde Valley, and Torres held that the settlement that plaintiffs had with Dr. Schlesinger had an effect on claims that were derivative. And I think as you recognize and as the trial court clearly stated, the court struggled a bit with what claims actually were being formulated and what were being made, but we do believe the court was ultimately correct when the court concluded that the claims of negligent supervision, negligent credentialing, and hiring were derivative of Dr. Schlesinger's fault and therefore would be precluded by both the Verde Valley case and by Torres. And so on that basis, we think the trial court was correct and should be upheld.
Would you agree that there are some hospital administration liability claims that remain?
I recognize that this is a Rule 54B judgment, which implicitly requires that there be claims made. I may not be able to articulate them that clearly, and I don't know what viability they have if they necessarily involve Dr. Schlesinger's eventual surgery. But yes, this is supposed to go back at some point, or supposed to continue, I should say, because we have a Rule 54B judgment. As far as plaintiffs' other arguments go, I don't think that Law and Torres need to be looked at with respect to Ucata. Law is a 2007 decision, and Ucata came along in the mid-'80s. So Law was certainly, the Law versus Verde Valley case is certainly was issued and promulgated based on the Ucata principles. I don't think there's a chilling effect that would happen in this case. Arizona courts have held that even when a party is mistaken about the effect and believes that there still is the ability to continue to litigate, these settlements need to be given the preclusive effect and having the meritorious basis for them. And on that basis, we think that the Superior Court should be affirmed. To the extent that the plaintiff wants to focus on the Hyde Amendment, or the Hyde affidavit, I could address those, but it doesn't really seem like that's before the court, which would probably be the only basis for claims remaining. And I think those claims are probably better directed to the Superior Court should plaintiff try to revive the litigation after this. Unless this court has further questions.
No.
Thank you, Counsel. Mr. Wright, you may have the last word.
Thank you. Short word I love. If you read the brief by the appellees, the case, according to their view, turns on whether the negligent credentialing, negligent supervision aspects of the allegations against ISIS are derivative in nature. We believe that they are not. That is really the heart of the appeal. Are those derivative claims or are they independent negligence claims? If you imagine a hospital administration or a team of reviewers, credentialers, those who are reviewing the program and hearing about patient recovery, hear about patient complications and so forth, if they don't act within reasonable care or with reasonable care, then they can be held independently negligent for failing to fire the surgeon, failing to correct the surgeon, failing to establish policies and procedures that would affect how the surgeon proceeds, what kinds of surgeries, the extent of the surgeries, and so forth. That's something that is a hospital administration type of work that should be done with reasonable care. The dismissal of the case by Dr. Talamanti was on those very issues. Are those derivative in nature, or are they independent in nature? That's what you've got to decide. It's our view that those are independent acts of negligence in failing to adequately supervise. Thank you.
Thank you. Counsel, thank you. We appreciate your argument today. You've given us much to think about. We appreciate your briefs as well. We'll take the matter under advisement. We'll issue a written ruling in due course. We stand adjourned pending our next oral argument. Thank you.